Okay, it's 10 o'clock, so I think I'll get started. I'm sure people may log on after we get started, but that's okay, they can get caught up. My name is Christine O'Neill. I'm the Assistant Director of the New York State Committee on Open Government. And today we're going to talk about the New York State Open Meetings Law and focus particularly on the use of remote access platforms under both the Open Meetings Law as it existed a couple of years ago and as it exists currently now through January 15th of 2022. Anyone that's interested, this is my contact information. Anyone is welcome to call or email our office with questions. In addition to myself, we have our executive director, Shoshana Boulay, who is available right now. She's, well-deserved vacation, but normally she's available for questions. Our senior attorney, Kristen Smith, so keep that in the back of your mind. If there are two Kristens in our office, and if we give you, for example, a last name when we return a phone call or when we contact you, keep our last name in the back of your head because we do have two. Given such a small office, it's a coincidence, but we have two Kristens in our office right now. So it's myself, Kristen O'Neill, Kristen Smith, and we also have been given an Excelsior Fellow for 2 years, and his name is Jake Forkin. All of us are available to answer your questions about the Freedom of Information Law, the Open Meetings Law. Our phone number is over there on the screen. There's our website. That's my direct email. And at the end of the program, I'm also going to give you an email address for our office as a whole. It's our office account that all of us have access to for answering questions. New York State Open Meetings Law is codified in Public Officers Law, Article 7, Sections 100 through 111. The easiest way to find it, and we try to keep it up to date anytime there's an amendment, is on the Committee on Open Government's website. We have a copy of both the Open Meetings Law, the Freedom of Information Law, and the Personal Privacy Protection Law. And as I stated, it is available. Excuse me. I just noticed someone said my audio is difficult. It's difficult to hear. Is it still a problem? If someone want to send me a comment and let me know if my audio is still off. I'm going to keep going, but if someone so I'm breaking up. I wonder what the problem is. I'm going to try opening up my laptop and see if that helps. I don't want to. Is it any better with my, not that you guys know that, but I have my laptop open now. Does that make any improvements? Good. Okay. Wonderful. Thank you for letting me know that. I would hate to go through the entire program with you guys not being able to hear me. Okay. So I'm sorry. So as it's talking about the text of the Open Meetings Law, the Freedom of Information Law, and the Personal Privacy Protection Law are on our website. We do try to keep it up to date. So hopefully if you're looking for the text, hopefully you'll always get an up-to-date version on our website. Someone is telling me that they can't hear anything. That might be on your end because I've gotten feedback from others saying that they can hear me clearly now. The legislative intent of the Open Meetings Law when it was passed in 1976 was that it is essential that public business be performed in an open and public manner and that citizens be fully aware of and be able to observe the performance of public officials. Citizens have the right to attend and listen to the deliberations and decisions that go into the making of public policy. That was the legislative intent. You'll notice on the PowerPoint that I emphasize some language there. And the reason why I emphasize that language is because currently, under Chapter 417 of the laws of 2021, which Governor Hochul signed into law at the beginning of September, it's substantially mirrors the language of the executive orders that were in place during the declared disaster emergency, but it allows public bodies to prohibit in-person attendance, and it allows as long as the public body affords remote access. So we're going to talk about that in some detail. But right now, the public doesn't always have the right to observe the performance of public officials, and they don't always have the right to attend in person the deliberations of public bodies. So we'll focus a little bit on Chapter 417. So on September 2nd, 2021, Governor Kathy Hochul signed into law Chapter 417 of the laws of 2021, which in part authorizes most public bodies to meet and take such action authorized by law without permitting in public, in-person access to meetings, and authorizes such meetings to be held remotely by conference call or similar service, provided that the public has the ability to view or listen to such proceedings and that such meetings are recorded and later transcribed. As I mentioned, the language of Chapter 417 substantially mirrors former Executive Order 202.1, which was issued in March of 2020. Written guidance from our office relating to Executive Order 202.1 can be found on the Committee on Open Government's website under Open Meetings Law Advisory Opinions, key phrase, declared disaster emergency. So the Open Meetings Law Advisory Opinions, the numbers that you see up on the PowerPoint, those are the advisory opinions that we prepared while EO 202.1 was in effect. Because Chapter 417 substantially mirrors EO 202.1, those advisory opinions can be just as helpful in interpreting Chapter 417 as hopefully they were in interpreting EO 202.1. At this point, Chapter 417 is scheduled to be repealed on January 15th, 2022. At this point, we don't know what's going to happen after that. It's possible that it will be extended. It's possible that the legislature will act and make other amendments to the Open Meetings Law, or it's possible that we may go back to the Open Meetings Law as it existed a couple of years ago, pre-COVID. The thing to keep in mind is that the Open Meetings Law is, or excuse me, the Chapter 417 is permissive. It allows for remote meetings, but does not require them. If a public body wishes to have an entirely in-person meeting, it is free to do so. Prior to the passage of Chapter 417, in order for a member of a public body to attend and participate via video conferencing, the Open Meetings Law required first that the public be provided with an opportunity to attend, listen, and observe at any site at which a member participates. As Chapter 417 authorizes public bodies to meet and take action without permitting in-public, in-person access to the meetings, public bodies are not currently required to comply with Section 103C of the law. So in other words, if you have a member of a public body that is attending via the use of video conferencing, that individual does not need to open their location to the public. If they're video conferencing from their homes or their offices, they don't need to open those locations to the public, as long as the public body complies with the rest of Chapter 417. Pre-Chapter 417, notice of the meeting was required to include the locations of the meeting, including the locations of the members who plan to attend via video conferencing. If video conferencing is used, the language of the law states that video conferencing is used to conduct a meeting, public notice for the meeting shall inform the public that video conferencing will be used, must identify the locations for the meetings, and state that the public has the right to attend the meeting at any of the locations. Post-Chapter 417, if a public body chooses to prohibit in-person attendance, The notice does not need to include the locations from which members are attending, and does not need to include the statement that the public has the right to attend the meeting at any of the locations. The thing to remember about Chapter 417 is if a public body is taking advantage of any of the benefits of Chapter 417, for example, allowing its members to participate via teleconference or video conferencing, it also has to take on the responsibilities of Chapter 417, which means providing remote access to the public as well, and also recording and later transcribing its meetings. If a public body chooses to allow in-person attendance at its meeting, it must comply with the following provisions of the Open Meetings Law. Section 103B of the law states that public bodies shall make or cause to be made all reasonable efforts to ensure that meetings are held in facilities that permit barrier-free physical access to the physically handicapped, as defined in Subdivision 5 of Section 50 of the Public Buildings Law. My shorthand for this is that the locations from which a public body is holding its meetings must be ADA compliant. A second requirement is public bodies shall make or cause to be made all reasonable efforts to ensure that meetings are held in an appropriate facility which can adequately accommodate members of the public who wish to attend such meetings. So here, what you want to keep in mind is if you're having in-person meetings, if a public body is having in-person meetings, it needs to hold those meetings in a location that can accommodate the size of the crowd that they anticipate will want to attend. So using, for example, let's say you have a school board, and sometimes the school board has its meetings in an elementary school library, sometimes they have their meetings in a high school auditorium. If the school district, if the school board knows that an upcoming meeting is going to be of significant public interest and that they anticipate quite a crowd will want to attend, they're going to want to hold their meetings in the largest location available to them. So if it's a hot topic issue, they're probably going to want to have the meeting in the high school auditorium as opposed to the elementary school library. But going back to the basics of the Open Meetings Law, the law governs the conduct of meetings of public bodies. And that term is defined as any entity for which a quorum is required in order to conduct public business and which consists of two or more members performing a governmental function for the state or for an agency or department of the state or a public corporation or a committee or subcommittee or other similar body of such public body. So the questions to ask is, have two or more people been given the authority to act collectively? So we've got things like town boards, village boards, city councils, county legislatures, county boards of supervisor, the New York State legislature, school boards, boards of fire commissioners, library boards of trustees. There are thousands of units of local government across the state of New York, and many of them have governing bodies. In addition to governing bodies, you also have public bodies such as the Committee on Open Government. The Committee on Open Government is an 11-member public body that is also required to comply with the Open Meetings Law because it is created by statute and serves a necessary governmental function. Committees made up of members of the larger body, either entirely of the larger public body or primarily of the larger public body, are going to be their own public body. So backing up a little bit, what I mean by this is, let's say, for example, you have a 9-member school board. And the 9-member school board, a quorum of that school board is going to be, 5 members, because it's a majority of the total membership is what a quorum is. However, if that school board appoints 3-member committees, so you have perhaps a finance committee, a curriculum committee, a student safety committee, any number of things. If you appoint, for example, 3 of your board members to serve on those committees, each of those individual committees then become their own public body subject to the open meetings law. So you have a 3-member committee. That committee is a public body, and 2 of the 3 make up a quorum of the public body. So I just mentioned, I referenced a quorum, the majority of the total membership. Quorum is defined in New York State General Construction, and it states that whenever 3 or more public officers are given any power or authority, or 3 or more persons are charged with any public duty to be performed or exercised by them jointly, or as a board or similar body, the majority of the whole number of such persons or officers gather together in the presence of each other or through the use of video conferencing. And here I'll note that it can also be held in compliance with Chapter 417, shall constitute a quorum. Not less than a majority of the whole number may perform and exercise such power, authority, or duty. And for the purpose of this provision, the words whole number shall be construed to mean the total number which the body would have where there are no vacancies and where none of the persons or officers disqualified from acting. So again, I'll use our own public body as an example here. At full strength, the Committee on Open Government is supposed to have 11 members. Right now, we only have 9. But still, a quorum of the Committee on Open Government is still 6. It's always going to be 6, regardless of the number of people currently serving on the Committee on Open Government, or regardless of the number of people who show up for a meeting. It's always going to be 6. You look at the total number of people that should be on that public body, and that's how you determine what a quorum is. Someone just sent me a note saying to check the lobby to let folks in. We don't have a lobby, so don't know what to tell you. I don't have a lobby. People should just be able to automatically be able to enter. There's no lobby. While Chapter 417 is in effect, members of a public body that participate remotely by conference call or similar service count towards a quorum. They're allowed to fully participate and they can vote. So even if you have a member of the public body that is only participating by conference call, right now, while Chapter 417 is in effect, that counts. That person count them just as if they were standing in the room with all of the members. They can fully participate, they can vote. Another thing to keep in mind is there does not need to be a majority of the total membership of the board in any one physical location for a quorum to exist. For example, when the 11-member Committee on Open Government meets, 4 members could be present in Albany, there could be 3 in Buffalo and 3 in New York City. In that situation, there's no quorum in one physical location, but because they're all participating via video conferencing, they all count towards a quorum. Anyone that's attending via video conference counts towards a quorum. And then the alternative, all 11 members could participate via conference call or similar service from their own private locations and still be counted towards a quorum. Right now, if we're having a remote meeting, past couple of meetings, our own meetings, we've just been having WebEx meetings where everybody participates from their own location. They're sitting in their offices or their homes, and even though we certainly don't have a quorum in one physical location, because they're attending via a permissible method as established by Chapter 417, they count towards a quorum. The Open Meetings Law defines the term meeting. The Open Meetings Law defines meeting as the official convening of a public body for the purpose of conducting public business, including the use of video conferencing for attendance and participation by the members of the public body. That's how the term is defined. Right now, until January 15th, it can also be in compliance with Chapter 417. There is no authority for a public body to take action outside of a meeting. any vote, any consensus, any action taken by a public body must occur within the context of a meeting held in compliance with the open meetings law. And then many people say, well, does this constitute a meeting? Does this type of a gathering constitute a meeting? You ask, is there a quorum present? If yes, are you there to discuss public business? If yes, you're having a meeting, regardless of the intent or lack thereof to take action or how the gathering is characterized. So, for example, there's no legal distinction under the open meetings law between workshops and work sessions and agenda sessions. There's no distinction between regular meetings and special meetings. Under the open meetings law, there is distinctions under other statutes sometimes. There's no really such thing as a pre-board meeting. Any gathering of a public body for the purpose of discussing public business is a meeting, so there never really should be a pre-board meeting. It should be all deliberations and discussions should be part of a meeting held in compliance with the open meetings law. There are other types of gatherings that may or may not be required to comply with the open meetings law, depending on the content, depending on what occurs at these gatherings. One example is a site visit. If a quorum of a public body goes to, for example, an off-site physical location, maybe it's a piece of property that they're considering purchasing, maybe it's a facility that the municipality owns and needs repairs, and they're essentially being taken on a tour of the property or the building, and someone is providing them with information. Maybe it's a real estate agency, maybe it's a facilities manager, and essentially the public body or the individuals who are members of the public body are simply there to gather information. If they can refrain from engaging with each other and discussing how to proceed in relation to the property or the building, the likelihood is it's not going to be considered a meeting subject to the open meetings law. And part of this is for practical purposes. For example, if you have a piece of property that the government entity does not own, you really have no right to invite the public onto that piece of property. So the goal there would be to have the members of the public body attend and listen, maybe ask questions of the person who's giving the presentation, but to refrain from engaging with each other and acting collectively as a public body. They want to just listen, gather information, and then bring that information back to a meeting that's being held in compliance with the open meetings law. Another situation that comes up on occasion, there are public bodies that have referred to going on retreats, and they say, well, it's a retreat, it's not a meeting subject to the open meetings law. Well, that depends on what you plan to discuss at that retreat. If the purpose is, for example, team building exercises, or it's more of an educational seminar, that's fine. They can, members of the public body can go and talk about things that do not relate to the business of their particular public body. On the other hand, I've also been told about situations where you have maybe a school board and they use these retreats as a way to discuss long-term goals for the school district. Well, that's a meeting. That's a meeting subject to the open meetings law and should not be characterized as a retreat that can be held outside the public eye. Another situation that comes up fairly frequently, earlier I talked about, for example, a 9-member school board and a 3-member finance committee. If a non-committee member of the school board would like to attend that committee meeting, they must be permitted to do so, even if the number of non-committee members that show up to the committee meeting would ends up being a quorum of the full school board. It's okay as long as the non-committee members sit in the audience and act as if they were any other member of the public. They should not be, for example, sitting up at the dais and actively participating with the committee members, because once they do that, it puts on the appearance that they are part of that committee. And if you end up having a quorum of the school board, then you have a meeting of the school board, which you may not, which the likelihood is the public were not notified that it was going to be a meeting of the school board. They were only notified that it was going to be a meeting of the committee. So if a non-board member wants to attend a committee meeting, they must be allowed to do so. They need to sit in the audience and sort of zip it. They can't speak. Or if they are allowed to speak, they should only be allowed to speak to the extent that any other member of the public is allowed to speak. And then, of course, there's situations such as social gatherings. Maybe you're having a holiday party around this time of year. Maybe over the summer you have a 4th of July barbecue for your municipality. And that's fine. Your public body is more than welcome to attend those social gatherings as long as they refrain from engaging with each other collectively as a body and discussing public business at those social gatherings. So pre-COVID, the definition of meeting requires either a physical presence or the use of video conferencing. While Chapter 417 is in effect, teleconferencing is also permitted. Regardless of whether it was pre or post-COVID, the public body cannot conduct a meeting via email. Public bodies cannot take action, cannot make decisions via email. It would also encourage members of public bodies to not engage in substantial deliberations that lead to decision-making via email. And I'm not saying that members of the public body cannot share information via email, that they can't. Maybe they found an interesting article or data that they think other members of their public body will find useful. Certainly, go ahead and share that information. Maybe someone has drafted a document that they would like the other members of the public body to take a look at prior to the next meeting. Fine, go ahead and share that information via email. But a best practice to avoid any inclination that the public body is not acting consistent with the open meetings law, they should refrain from engaging in substantial deliberations. If they do start engaging in those types of deliberations, my recommendation would be to repeat those deliberations in the context of an open meeting so that the public knows that, that all of these issues were given careful thought and consideration before decisions were made. Nothing annoys the public more than showing up to a meeting of a public body and having a public body merely vote on an important issue without any discussion. It doesn't reflect well on the public body, and it seems to reflect to the public that perhaps deliberations were occurring behind closed doors, and that, as I said, that just doesn't reflect well on the public body or the municipality. Notice. Notice of all meetings must include the date, time, and location, and or instructions for virtual attendance. So if you're having remote meetings or if you're having hybrid meetings, the notice should include, if it's completely remote, it should include just the instructions for virtual attendance, such as maybe a live stream address or a WebEx or Zoom address, or at least at a minimum a teleconference phone number for people to call into. If you're having hybrid, it should include the physical location and that remote access information. And that notice prior to every meeting must be given to the media. That does not mean that the public body is required to purchase a legal notice. They just must provide notice of the meeting to the media. The notice must be placed in a designated physical location. And if the agency or public body has an active website, the notice must be posted on that website. The notice must be provided at least 72 hours prior to a meeting that has been scheduled at least 1 week in advance. So in other words, for meetings, regularly scheduled meetings, the notice must be given at least 72 hours prior. For meetings that are held on short notice, the statute says that notice must be given to the extent practicable at a reasonable time prior to the meeting. Now, the law doesn't state when a public body is allowed to have meetings held on short notice, but the courts have weighed in. The courts have suggested that the propriety of scheduling a meeting less than a week in advance and providing less than 72 hours notice is dependent upon the actual need to do so. Would harm be caused by waiting either till the next regularly scheduled meeting or waiting until you can give the full 72 hours notice? Certainly there are going to be times when it's appropriate for a public body to have a meeting on short notice because harm would be caused by waiting. But if no harm would be caused, the courts have weighed in and stated that the public body should be waiting. So there have been a couple of recent amendments to the open meetings law. On October 19th of this year, Governor Hochul signed into law Chapter 481 of the laws of 2021, which amends Section 103E of the law to require that records to be discussed at a meeting be made available to the extent practicable upon request and posted online at least 24 hours before the meeting. The obligation to make records available to the public upon request prior to or at the meeting and to post the records on the agency or public body website prior to the meeting has been in effect since February 2012. After this law was signed in, after Chapter 481 was signed into law, I started to get way too many phone calls from members of municipal employees, government employees, members of public bodies that thought that this was an entirely new requirement, this requirement to make records available to the extent practical prior to the meeting. It is not a new requirement. As I said, it's been in effect since February of 2012, almost 10 years at this point. The only thing that changed was that this amendment places a 24-hour minimum time frame for making those records available. So for all the members of the public body that think, oh, this is a new obligation that we've never had to do before, well, you have always been required to do it. It's just, excuse me, that now you just have a time frame for when you have to do it. It used to be that you could post the information 5 minutes before your meeting and you would have been in compliance. Now it's a 24-hour minimum time frame. So the records that are supposed to be made available either upon request or on an agency website are proposed resolutions, laws, rules, regulations, policies, or any amendments to any of those things. Or records or portions of records that are public under FOIL that are scheduled to be discussed during the open meeting. And those must be made available upon request at least 24 hours prior to the meeting and shall be made available online at least 24 hours prior to the meeting if the agency maintains a regularly and routinely updated website and utilizes a high-speed internet connection. The law states the agency may, but is not required to, spend additional monies to implement this section. A point of clarification is that this does not mean that a public body is prohibited from introducing resolutions that were or motions that were not made available prior to the meeting. Sometimes it's not practicable for that resolution to be made available prior to the meeting, and if that's the case, the law gives a little bit of wiggle room. If it is not practicable to make the proposed resolution available prior to the meeting, an agency still, or a public body still can introduce that resolution at the meeting, but you just keep in mind that the courts are going to look to see whether an agency or public body is making reasonable efforts to comply with the law. You know, the mere fact that somebody just didn't get around to it is not that it's not practicable. It's that, you know, a situation where it might not be practicable is that edits to the resolution were being made right up to the last minute. Maybe that's the reason why it was not practicable to have it available prior to the meeting. But in most cases, any records scheduled to discuss are supposed to be available prior to the meeting. Minutes of a meeting of a public body must include all motions, proposals, or resolutions and the votes thereon. Executive session, a public body only needs to take minutes of an executive session if action is taken in an executive session. If a public body merely deliberates in executive session but does not vote in executive session, no minutes need to be prepared. Those minutes must be prepared and must be available within 2 weeks for an open session and 1 week for an executive session. And it does not matter whether the minutes are unapproved or still in draft form. If someone makes a request for that information, or if you're going to be required to post the minutes online before they've been approved, you can mark them unapproved or draft, but you still need to comply with the elements of the Open Meetings Law that requires that those minutes be made available to the public. On November 8th of this year, Governor Hochul signed into law Chapter 587 of the laws of 2021. So this has been an active year for the Open Meetings Law. And that amends the Open Meetings Law to require that agencies that maintain a website and use a high-speed internet connection to post their meeting minutes on its website within 2 weeks of the date of the meeting or within 1 week of an executive session. The law also states that an unabridged video recording or unabridged audio recording or unabridged written transcripts may be deemed to be meeting minutes for the purpose of that requirement. So background and explanation of that is this does not mean that a video recording, audio recording, or transcript takes the place of minutes generally. Public bodies are still required to prepare minutes in compliance with Section 106. However, if instead of posting, for example, unapproved minutes on their website within 2 weeks, they would prefer to post the unabridged video recording or unabridged written transcript, they can do that. It's the only thing that video recordings, audio recordings, and written transcripts replace, the only time they replace meeting minutes is for the purpose of posting online. But still, anyone who's responsible for taking meeting minutes has to keep in mind that they are still required to prepare meeting minutes. The recordings and the transcripts will not be sufficient to comply with Section 106. It's only sufficient to comply with the posting requirements. Recordings. Any meeting of a public body that is open to the public shall be open to being photographed, broadcast, webcast, or otherwise recorded and/or transmitted by audio or video means. That means if you're having an open in-person meeting and someone wishes to come in with their iPhone, with their smartphone and start recording, they're free to do so. They don't need permission from the public body. They don't need to notify the public body. They are free to record. They can't be prohibited from recording. An agency is not obligated to record its own meetings unless the meeting is being held pursuant to Chapter 417. So if you're having a remote access meeting, if members of the public are being prohibited from attending at any location, the public body is going to be required, or the agency that hosts the public body is going to be required to record its meeting and later transcribe it. An agency or public body may establish reasonable rules to limit disruption or interference, and model rules are available on the Open Government website. So, for example, if you want to establish, a public body wants to establish reasonable rules to ensure that the people who are recording the meeting are not disrupting the meeting, are not getting in people's faces, are not interfering with the ability of the public body to have a reasonable and calm meeting, then it is they can establish those types of rules. Executive session. Executive session is defined in Section 102, Subpart 3 of the Open Meetings Law as a portion of an open meeting, not open to the public. Executive session is never going to be prior to or separate from an open meeting. Executive sessions must always be held within the context of an open meeting. Public body must make a motion to enter into executive session during an open meeting. They must vote on the motion to enter into executive session during an open meeting. And that motion must be specific enough to reflect to the other members of the public body and to the public generally that the public body is going into executive session for a proper purpose. So public bodies should not be just simply parroting the language of the statute. They should be sure that they are using language that reflects they understand when and why they're allowed to go into executive session, and that the reason they're going into executive session at this point is compliant with law. Here up on the screen is a list of the reasons that a public body is permitted to go into executive session. I'm not going to go over all of them in great detail, but I will put out with my big capital letters, public bodies should not ever be making a motion to enter into executive session to discuss personnel matters. It is not sufficient to comply with law. The word personnel does not appear in the open meetings law. What does appear in the open meetings law is that a public body is allowed to move to enter into executive session to discuss the medical, financial, credit, or employment history of a particular person or corporation, or matters leading to the appointment, employment, promotion, demotion, discipline, suspension, dismissal, or removal of a particular person or corporation. And I'm not, in fact, I'm discouraging public bodies from using the word personnel, but I'm also discouraging public bodies from parroting the language of the statute. Pick the language that applies to the situation that you're going to discuss. Have you received resumes from applicants who wish to be chosen to serve? You know, maybe you're in a municipality and you are hiring people to work in the payroll department, the highway department, whatever the case may be, and you've received resumes, and you want to discuss the resumes in executive session. Perfectly acceptable reason to enter into executive session. An appropriate motion may be, I move to enter into executive session to discuss applicant for employment for the positions A, B, and C. That would reflect to the public that you're going in for a proper purpose and give enough of a reason, give enough detail to show that you are going in for a proper purpose without defeating the purpose of the executive session. You don't need to identify the applicant. If you're discussing disciplinary matters, you don't need to identify the name of the employee who may be subject to disciplinary investigations. You just need to be specific enough so that the public knows you're going in for a proper purpose. In terms of public participation, under the open meetings law, public participation is not required. No, open meetings law does not require public bodies to allow time for public comment, public participation, privilege of the floor, any of those terms that you've heard. However, many public bodies do allow for time for public participation. And those public bodies can establish reasonable rules, and those rules should be implemented fairly and consistently across the board, regardless of the content of what the people wish to say. For example, if you have an important issue that's being presented to a public body, and you have people that are in favor of a particular issue and some people that are not in favor of that issue, you need to give them both equal time. And any rules that you put in place regarding public comment need to be implemented across the board, regardless of a speaker's opinion on a particular topic. I'll note here that hearings are not the same as meetings. Hearings are often required to comply with the open meetings law because they are held by a public body, but in addition, there are other statutory obligations that are created pursuant to a myriad of other statutes that require public participation, require public comment, but that obligation to have public comment does not come from the open meetings law. There are two avenues for meeting behind closed doors in the open meetings law. The first was the executive session that we've already discussed, and the second are referred to as exemptions. The exemptions are located in Section 108 of the open meetings law, and if an exemption applies, the open meetings law does not. It is as if the open meetings law does not exist. So the three exemptions are judicial or quasi-judicial proceedings, except for proceedings of the Public Service Commission and zoning boards of appeals. So a quasi-judicial proceeding would be the last step at a government level where a public body is having some type of hearing and makes a determination that can only be challenged through an Article 78 proceeding. It would be the last step in that agency's decision-making process. If that is what it is, it might be considered a quasi-judicial proceeding and would be exempt from the open meetings law. Deliberations of political committees, conferences, and caucuses are exempt from the open meetings law. So if you have a 5-member town board and 3 members are Democrats and 2 members are Republicans, the Democrats are free to meet and discuss whatever they want, even though they constitute a quorum of the town board. They can't vote, but they can discuss whatever they want. If it's 2 to 3, if it's 4 to 1, the courts have established an exception that states that if you have a public body that is made up entirely of a single political party, so for example, if you have an entirely Republican town board, all 5 members are Republicans, in that limited circumstances, the courts have stated that you can still have political committee meetings, but you have to limit those discussions that are held at those political committee meetings to political business and save discussions for town board business for open meetings. But that's not established in the law, it's established by case law, I should say. The third exemption applies to matters made confidential by federal or state law. For example, for school boards, discussions relating to students that are made confidential by federal statute. And a very common example are meetings with an agency attorney, like a town attorney, a city council, county attorney, meetings with an agency attorney that are covered by the attorney-client privilege. If you have a gathering of a public body with their legal representation, with their town attorney, with their county attorney, and the attorney is playing an active role in providing legal advice, that conversation is likely going to be covered by the attorney-client privilege, and the gathering would be exempt from the open meetings law. But the attorney needs to be playing an active role. The attorney's mere presence at a meeting does not convert it to a gathering that's covered by the attorney-client privilege. The attorney needs to be playing an active role in actually providing legal advice that would be covered by the attorney-client privilege. Once the attorney stops playing an active role, the public body needs any continued discussion by the public body needs to take place in the context of an open meeting. Finally, noncompliance and enforcement. Enforcement of the open meetings law is through the initiation of a civil practice law and rules Article 78 proceeding. The Committee on Open Government does not have enforcement authority. We do not have the authority to investigate complaints. We merely have I shouldn't say merely, I hope people find it valuable, but we have the ability to provide advice and legal opinions regarding the open government statute. But we do not have the authority to investigate complaints, and we do not have the authority to compel an agency or public body to take any particular action. If any aggrieved party may bring an Article 78 proceeding challenging an action or challenging perhaps challenging the way in which a public body has been holding its meetings, Any aggrieved party can bring those proceedings. If the petitioner prevails, the court has the authority to award costs and attorney's fees to the petitioner. They can invalidate actions that are taken at meetings that they determine to be held in violation of the open meetings law, or as a result of substantial deliberations held at meetings they believe to have been held in violation of the open meetings law. And lastly, they can also require that a public body take training from our office. So last, I want to remind everyone that anyone is welcome to contact the Committee on Open Government by telephone or by email with questions, whether you're a government employee, whether you're a member of the public, media representatives, anyone is welcome. That's our phone number, which is available on our website. That's our office email address, so if you're not able to reach me or not at the office, you're always welcome to email the office generally, and someone will get in touch. Before I end, I just want to kind of take a flip through the chat and see if there's any questions that may have come up in the chat that I did not address. Just so everyone knows, this program is being recorded, and it will be available on our website. If you go to our homepage and scroll down a bit, you'll find a link to training materials and recordings. So you'll find a copy of a recording of this program and previous programs on our website. In addition, the training materials, the slideshow that you're seeing right now, will also be available online. The version that's currently up right this minute, unless our IT staff has been super fast, I asked this morning for them to post an updated version, because I realized that the version that we had on our website was a little dated. So just this morning I requested the updated version be posted, and it's in that same spot. There's a section specifically dedicated to training materials and recordings. You can find it there. I do ask that people don't email me and ask, because I tend to get an influx. So just go to our website. That information will be available there. Someone asks about community boards. I'm assuming we're talking about New York City-based community boards. Community boards are public bodies subject to the open meetings law, and any committee that is made up of members of the community board are also public bodies subject to the open meetings law. Someone asks if there's an agenda item to be discussed that includes supplemental documents. Must they also be posted to our website prior to the meeting? Is it the same requirement to both voting and non-voting bodies? So I'll start first. Is the open meetings law applies to all public bodies. There is no distinction. I'm not really sure what's meant by both voting and non-voting bodies, because all public bodies only have the authority to act collectively. That's what a public body is. A public body only has the authority to act collectively. So to some extent, they all must be voting bodies, because any decision made by that entity must be made a vote. And what Section 103E has required for the past almost 10 years is any proposed resolutions, laws, regulations, policies, or any record scheduled to be discussed are required to be made available consistent with Section 103E. If the record is scheduled to be discussed, it is subject to the requirements of 103E. Someone asks, how are issues handled when the audio is not audible to the public and the closed caption is not easily understood for handicapped folks? I'm not really sure what you're asking me. You want to bring these, if your public body, if they're having technical issues, well, bring them to their attention. If they aren't aware of them, hopefully they will fix them. If they continue to have meetings with technical difficulties that they've been made aware of, it's possible that an individual could allege that they are not holding their meetings in compliance with the open meetings law, and they could be subject to an Article 78 proceeding. Someone asked, does a public body have to vote to adjourn a meeting? There's nothing in the open meetings law that discusses adjournment. Public is participating via Zoom. Can the board require you to identify yourself? In our opinion, if an individual wishes to remain anonymous, they should be free to do so. For example, if you're logging on via Zoom, there's no real obligation for you to provide your true name on those logins. You could log on as Jane Doe. The public body should allow you to attend and speak at meetings without providing your name. That doesn't mean that they can't ask for it. It just means that your ability to attend a meeting and your ability to speak at a meeting should not be conditioned on your willingness to provide your name if you're not willing to. Oftentimes it's valuable to provide your name and perhaps even an address, because if the public body knows who you are and maybe where you live, it's going to weigh in, it's going to be a factor in determining how much weight should be given to your opinion. For example, if you've got somebody, here, I live in the town of Bethlehem. If I log on and want to speak, hopefully they would give my opinion more weight than somebody who has no connection to the town of Bethlehem and has just decided to randomly log on from California. So it says the committee cannot take a vote that is binding all votes. I mean, this ultimately, the statement is a committee cannot take a vote that is binding all votes are at the general board meeting, and that's fine, but it's a vote. It's a vote to make a recommendation to the full board. It's still a vote. So it says for community boards, there's a clear expectation for resolutions and agendas to be posted explicitly on their website 24 hours in advance as a matter of routine. I hesitate to use the word agenda because the term agenda is not used in the open meetings law. There is no reference to the term agenda in the open meetings law. It is records scheduled to be discussed. To the extent practicable, resolutions, laws, rules, regulations, and records scheduled to be discussed are supposed to be made available in advance, 24 hours in advance, in compliance with Section 103E. If some members of a public body participate remotely, but the meeting itself is open to the public, must we also allow the public to participate remotely? The answer is yes. I think I mentioned earlier, if you're taking advantage of the benefits of Chapter 417, you also have to take on the responsibilities of Chapter 417. So if you're allowing one of your members to sit at home or sit in their office and attend remotely without opening their location to the public, then you also have to provide that opportunity to the public. It sort of makes sense. You're giving your own members of public body a benefit. You should be also giving that same benefit to members of the public. What does later transcribe mean in terms of time? The law is silent in terms of what later transcribe. It could be when someone asks for it. I don't know. The executive order was silent as to time limits, and Chapter 417 is silent. This person says our town does not transcribe any video. Minutes are not available until they are foiled. In terms of transcription, honestly, I don't have a problem with that. If no one asks for the transcript, I don't see why an agency or public body would go through the effort of preparing a transcript. It just says later transcribed. Yes, it's a requirement, but if it's not requested, if nobody wants it, I can see why they may hold off. In terms of minutes, there are clear obligations as to when minutes must be available, and recently there's the obligation to post those online, but that's a very recent requirement. Someone says, I think the open meetings law is silent on how long public bodies should leave up documents posted pursuant to 103. That's correct. The open meetings law is silent. How long should they be kept up? From our opinion, is they need to be kept up through the meeting. So that the point is that so that the public can follow along. That's the purpose of Section 103. is so that the public can read along and follow along while the members of the public body discuss. There's no obligation under the open meetings law, in my opinion, to keep them up after the meeting. I said, so in states that I flagged, when this is practicable, the resolution is drafted as an outcome of a committee meeting the night before. Maybe there's no time for the website to be updated, but this practicability should not be used as an excuse for the community board not to post resolutions on the website. As a matter of, no, I mean, it's to the extent practicable. Yes, if the agency or public body has the ability to get that information up on the website, it should be doing that. Penalties for non-compliance we discussed already. And that's it. That's all I've got. And I hope everybody has found this useful. I did record this program. It will be posted up on our website. So if you have colleagues or friends that might be interested, it will be available on our website probably by early next week. Again, I ask that you not email me and ask for me to email you the recording or the materials, because they will be posted up on the website, only because it becomes a little overwhelming for me to respond to those numerous requests. So I hope everybody has a lovely holiday season and Happy New Year, and I'll be back next month. I haven't scheduled it yet, but I'll be back next month with a Freedom of Information Law program. And then, you know, I'll keep continuing to do these programs for as long as people find them helpful, alternating between the open meetings law and the Freedom of Information Law every month. Great. Thank you very much, y'all. Have a good day.